John Schilling was charged with rape of a child in the first degree, indecent exposure, and 2 counts of child molestation in the first degree. The child was his stepdaughter, Madison. Mr. Schilling was married to a woman, Amanda, from 2011 to 2019. In addition to having 4 children in common, Amanda had 3 children from a previous relationship, including Madison. In 2019, CPS became involved with the family. During a period when Mr. Schilling was seeing his children through controlled visitation, concerns were raised about his interactions with Madison. When asked, Madison disclosed the SA incidents and charges were laid. Her disclosure was described in court by 2 witnesses. The defense argued hearsay, but the state argued it was offering the testimony to explain what prompted the initial conversation with Madison that ultimately led to law enforcement getting involved. This would be an exemption to the hearsay rule. Following the trial, a jury found Mr. Schilling guilty of indecent exposure and both counts of child molestation in the first degree. Now, Mr. Schilling is appealing his conviction, arguing 1. Hearsay was improperly admitted, 2. His trial counsel was ineffective, 3. The prosecutor committed prejudicial misconduct, 4. Cumulative error deprived him of a fair trial, 5. Insufficient evidence was presented to sustain a conviction for indecent exposure, and 6. Certain community custody conditions were impermissibly ordered. Let's take a look.
Thank you, Your Honors, and may it please the Court, Matthew Cataldo on behalf of John Schilling this morning. I'm here to present oral argument on his behalf. This trial was tainted from start to finish by multiple errors. Prosecutorial misconduct infected voir dire, the opening, and both closing arguments. To boot, Mr. Schilling had ineffective assistance of counsel, and worsening matters, the trial court admitted inadmissible hearsay. This is a cumulative error case in that regard. These errors either had a tendency to bolster unfairly SL's credibility, lower the state's burden of persuasion, and then weaken the defense's ability to rebut the charges. I want to start with misconduct, specifically the misconduct from the prosecutor during the closing argument. And I want to start there because it seems like the parties agree that the prosecutor's misconduct in vouching for the credibility of SL and impugning the credibility of Ms. Cesarwinski was improper misconduct. Seems like instead the disagreement there is that the misconduct doesn't rise to the level of flagrant and ill-intentioned, and I think that is incorrect. This was incredibly prejudicial misconduct.
Mr. Cataldo, can I just ask you, you began by indicating that this is a cumulative errors case. What if we don't find any error with any of the other allegations of error except for those comments during closing? Would that be sufficient to reverse?
It would. I do think that is flagrant and ill-intentioned, specifically the denigration of defense counsel. I think that is the worst misconduct in this case. In and of itself, that's sufficient to reverse if this court finds it's flagrant and ill-intentioned. I think it is. I want to focus on that point, on the denigration of counsel, because that was thematic in the rebuttal. That was the rebuttal closing from the prosecutor. Starts saying, wow, that Hollywood rendition was utter fiction. When I was briefing this, I picked out 3 instances of that misconduct in the rebuttal. It's kind of a misnomer because it truly was thematic. It was the point of the rebuttal to call defense counsel, this Hollywood screenwriter, to tell the jury that you should disregard it entirely. I think the Supreme Court has reversed for less, frankly, in Lindsay and Thorgerson. There, the prosecutor had called the defense counsel's argument, say, sleight of hand, a crock, or bogus. This is worse. Coming in and saying this is the latest rendition from this Hollywood screenwriter is so unnecessary. It's so improper that I think.
Does defense counsel kind of open the door to that by coming in and saying, well, I'm not a screenwriter and I can't write a script for this trial. And isn't this just a response to that? Doesn't prosecutor get to respond to something like that?
2 points, Your Honor. First, I don't really think this is a response just because of the tone of the prosecutor's argument is so inflammatory. If he had just said, hypothetically speaking, that he calls himself a Hollywood screenwriter, that he can't invent facts or something, that might be fine. But he took it multiple degrees further than that by saying it was utter fiction, latest Hollywood rendition that he'd planted in the jury's minds. that, of course, that they should just completely disregard. That is a step further. But even if that wasn't the case, this Washington Supreme Court in State v. Lindsay has said very clearly that even if the defense opens the door, so to speak, to some form of argument in closing, that does not give the prosecutor license to engage, go tit for tat, for example. The prosecutor is a quasi part of the judiciary, that they're held to a higher standard than.
Right, but in Lindsay, did they reverse on that issue?
Not entirely on the denigration of counsel, Your Honor. There were multiple instances. In Lindsay, there was also the vouching of credibility. I think that makes this case squarely in line with Lindsay. There are several other different types of misconduct here. I do want to touch on the misconduct during voir dire. Frankly, that isn't an issue that we see as much in Washington State. It is an issue that does come from United States Supreme Court precedent regarding voir dire for death penalty jury panels. But still in this state, under State v. Frederickson, we know very clearly that the prosecutor cannot use voir dire to indoctrinate the jury, get them to prejudge to a certain outcome, and to just preview the state's case for the jury. I think all of that happened here very clearly. This was the prosecutor's voir dire. It doesn't really touch on anything else besides clarifying for the jury that it's just going to be testimony, asking if that's sufficient multiple times to multiple veneer members.
Isn't that important though? Meaning, going back to my days in trial work, whether it's a DUI trial or a violent crime, a lawyer might ask a jury, is there anyone here that would have to have a breath test to convict someone of a DUI? And people will always, there's always someone that say, yeah, I need to have breath tests, or would you have to have DNA? And people always respond yes to that, and you don't have to have that to convict.
So I'll be honest, if that's all I had here, I would be making a different argument, but that's not all we have. We have questions that are closely approximating the facts of the case at the heart of the prosecutor's case, the credibility of SL. None of those questions were designed to ferret out prejudice. None of those questions were designed to ferret out this so-called CSI effect. They're just mirroring the issues with SL's credibility. Questions like, for example, is there going to be an issue for a veneer member if a child victim waits to disclose an allegation? Is a child victim expected to remember everything or just the very traumatic details? How are you going to weigh a child victim's credibility if they're saying different things at different times to different people? That's just the facts of this case. There's no reason to ask that. And how he was asking that is incredibly revealing. He's just pre-qualifying the jury. He's getting them to pre-commit, so to speak, to overlook those issues in the state's case. I think that is what distinguishes this case from the more run-of-the-mill, say, a DUI case where, yeah, I mean, some of those questions are fair ground. You do need to make sure the jury isn't, for example, going to weigh direct testimony over, say, circumstantial evidence. That's fair. But what happened here is a couple of steps farther than that, where he's asking just on the testimony point, is that going to be sufficient? Yes or no? Multiple people. Going down the line to then drill in on the problems with SL's credibility through that testimony, it's just whittling it down to the state's case. It's revealing that in the opening, one of the first statements from the prosecutor was just confirming that all of those questions, more or less, that is just our case. There's a massive delay here. She remembers different things at different times, but, you know, that's still enough. More problematically was explicitly closed that loop to say, hey, you guys already all agreed that this was fine. You agreed that we didn't need a perfect witness. You agreed that testimony was sufficient. I think that says very clearly what was happening here, that he did get the panel to pre-qualify themselves. And under Frederickson, even that's improper. The case that really is on point, State v. Williams from the Utah Court of Appeals, I think the closest case I could find, frankly, and those facts there are pretty much on point here. I want to touch on ineffective assistance of counsel, if there are no questions remaining about the misconduct. Regarding the ineffective assistance claim, starting with the improper impeachment, there was no reason from defense counsel's perspective, no strategic, reasonable reason.
Well, we're kind of Monday night quarterbacking this. So we look at the whole transcript and we can see what's going on. But don't you think during the time that this was occurring, when the defense attorney's sitting there, the state calls a witness, they call the mother of the victim. Wouldn't it be kind of the inclination of a defense attorney to impeach that person or to let them be impeached, given the time and place versus years later, perhaps?
I might be misunderstanding the question, Your Honor.
Wouldn't that be strategic at that point in the mind of the attorney? I mean, it's easy to second guess his decision now, but at the time and place, wouldn't that be a strategic decision?
No, I don't think so. Just because of what the answer that you had in the record was all you could have in the record. That's her denial. And I don't think there's her denial of speaking to Mr. Schilling in 2023 in violation of the no contact order.
But it's not just her denial, it's her credibility as a witness.
Sure.
And, you know, she got up there and said, the daughter came out and told me this, and that hurts Mr. Schilling. So Mr. Schilling's attorney could be sitting there going, well, this witness is not doing me any favors. If she gets discredited on the stand, then I'm in better shape. That's the strategic thinking.
I still think the facts tell a different story. At that point in time, her testimony, of course, was concluded. Most of her testimony mirrored Mr. Schilling's position in the case, that this was a rash, that they treated the rash by rubbing her vaginal area, and that she thought that nothing inappropriate happened. That was the sum and substance of her testimony. Then letting in completely unnecessary evidence that, hey, you know, she was actually talking to Mr. Schilling in violation of her testimony, that just impugns everything that she said favorably for the defense. Also, I think most problematically, it's just loudly implying that Mr. Schilling was violating this no contact order, which is a separate crime. And there's just really no reason for counsel to go that route. It really wasn't relevant to this case. She had just finished testifying. Most of it was favorable. Then you're really implanting this idea in the court's mind that, hey, you know, this might be an improper impeachment, but I'm going to let it happen. I can't think of any realistic strategic reason for letting that happen. You had already gotten her denial that she said, no, I haven't talked to Mr. Schilling since 2019. Everyone was stuck with that. External evidence to impeach her was just improper. I know I'm approaching my rebuttal time, so I will just reserve. Thank you, Your Honors.
Ms. Royalty?
May it please the court. My name is PK Royalty. I represent the state of Washington. The state requests this court affirm the convictions of Mr. Schilling, as there was no ineffective assistance of counsel and any prosecutorial misconduct was harmless error. I welcome the court's questions.
This is our busy week. It's our docket week. I was driving in early. It was either Monday or Tuesday. This is a true story. And I was coming down Monroe near Northwest Boulevard and saw a gentleman urinating into a bush as I drove by. That's what I saw. Is that indecent exposure? Is that enough to convict him of indecent exposure?
Well, this is not part of the record, but that has been enough to convict some people of indecent exposure, merely being in public and exposing themselves to someone in public.
I didn't see his genitals.
Oh, then probably not.
Well, here we have the victim. She made 3 statements about Mr. Schilling in the bathroom. She says that it says, think he went to the bathroom in front of me. And then there was a follow-up question. You mean you're there, you're seeing him do this? She said, yeah. And then later she said, when John went to the bathroom in front of you, was he standing up or sitting down? I said, standing up. There's no evidence in there at all that she saw him expose himself.
I apologize. I focused on the prosecutorial misconduct and ineffective assistance of counsel because that's what we were told to focus on. But from my memory, she testified that she did see him urinating and she was not used to seeing him in the bathroom with her. Also, she was approximately 11 years old at this time. There was no reason for him to be in the bathroom with her or vice versa. He stated he wanted her to come in with him because he was concerned about her being in the deli alone without him.
To be an exposure, even if they're in the bathroom, would he have to expose his private areas or something that's generally not revealable to public? Or is her standing behind him, just seeing his back, sufficient for indecent?
I don't know that that's in the record, that whether or not she saw him only urinating from the back or not, but still he chose to go into the bathroom, molest her there. And then when she told him to stop, he then proceeded to go to the bathroom. I don't believe she said, I didn't see his penis. I don't believe that's part of the record. She saw him urinating.
So would we infer that she saw his genitals?
I think that was enough for the jury to convict him on indecent exposure.
Question about the hearsay. It's my understanding that the brother and sister-in-law, and I use these terms just to help me keep track of everybody, brother and sister-in-law were allowed to testify that Amanda shared concerns about the victim, that the victim had disclosed inappropriate touching by Mr. Schilling. And the court allowed the general context of these statements, or allowed the brother and sister-in-law to testify to show why the sister-in-law approached the aunt. Is that correct?
Yes, that is.
So why did the brother get to testify?
He was also a witness to the mother, Amanda, making this statement.
Right. But if the statement is introduced to show why the sister-in-law did something,
I don't know that it was necessary. It may have been cumulative to have him also testify to that incident. And both of...
Go ahead.
Oh, thank you. The state does not believe that there was ineffective assistance of counsel in this case. When Amanda, the mother of the victim, testified that she had not had any communication with Mr. Schilling since 2019, the state had information that they had been in text communication right up until the trial in August of 2023. The prosecutor is the one who raised the issue that it was a collateral issue, but it was proof that she had not told the truth while testifying about her contact with him. He did say that it was a collateral matter and he wasn't sure it was relevant. The defense attorney, the trial counsel, then stated that it went to her credibility as a witness for everything that she said while she was testifying. And the court, after discussion with both trial counsel and prosecutor, agreed. And therefore, the detective introduced that evidence, but he also introduced the evidence that there was no indication Mr. Schilling was trying to influence Amanda with her testimony. So the fact that it was introduced did not necessarily prejudice Mr. Schilling. And in addition, the case on the statement of additional authorities that was filed by Mr. Schilling, State v. Bravo, that dealt with a collateral matter that was not allowed to be introduced, the status of the U visa of the victim and her sister. And Bravo held that collateral matter could be introduced because otherwise it would infringe on the constitutional right of Mr. Bravo to confront witnesses against him. So in a way, Bravo is similar to the Schilling case in that it was a collateral matter, but it could be used for legitimate purposes. Therefore, not objecting to it was not ineffective assistance of counsel. And encouraging the admissibility of the complaint under the hue and cry rule, which has been evolved to the fact of the complaint rule, allegedly 3 years after the offenses, or even longer for the case of the first count when she was 6 or 7 years old, is permissible under State v. Martinez.
Counsel, can I ask you, under that hue and cry, doesn't defense have to attack the credibility of the statement before the state can bring in evidence to show that it's consistent? I mean, I guess the state doesn't get to preemptively introduce evidence based upon its belief that defense counsel is going to attack the credibility of a witness, right?
Well, in this case, it was a motion in limine presented by the trial counsel.
Which one?
Not the
prosecutor? Or?
No, by the defense counsel. Okay. They wanted to suppress that information. And then the Mr. Schilling's claiming he was ineffective for withdrawing that request to suppress that information, that evidence, because he believed that it was admissible. So it wasn't the state looking to suppress it.
Understood. Sorry about that.
No, that's fine. When it comes to the prosecutorial misconduct in voir dire, the prosecutor asked questions, and rather than getting the jurors to commit themselves to vote in a particular way, he was looking for any particular bias that they may have when it came to what evidence they would need to see. Again, the CSI effect was important. And in cases like this of child rape or child molestation or indecent exposure, there's often no other witness to these crimes. And therefore, it's all based on the testimony of a child. And often children do not come forward for a variety of reasons for years or until they're asked specifically. In this case, the second incident of the first child molestation incident, but the second incident that was charged was the victim did testify that she told her mother immediately after it happened. And there was no hesitation on her part, but again, she was approximately 10 years old at this time. The mother did not report this to anyone. So what the prosecutor was doing was asking these questions, and defense rightfully objected to many of them. And at one point, the judge said, you need to clarify what you're looking for, a particular credibility issue or whatever it was. And that's what the prosecutor did then. He responded to the objections or the clarification that the court required in order to continue questioning the jurors, the potential jurors. When it comes to the denigration of defense counsel, the prosecutor was not denigrating defense counsel. He was responding to a hypothetical situation, a hypothetical story, an alternative version of the events in this case in his rebuttal closing argument, when he stated that after the defense counsel stated, I'm probably going to regret this, but here it goes anyway. And he presented this alternative possibility of what happened, and he called himself a screenwriter. So it was the prosecutor merely following up on that theme that the defense attorney had proposed in his closing argument. At the very beginning, this is in my briefing, but at the very beginning of voir dire, someone on the panel, on the jury panel, said that they were aware of the trial counsel and knew him to be a good attorney. And even the prosecutor stated on the record that he concedes he is a good attorney. So that is the opposite of denigrating your opposing counsel. It was responding more to the argument than...
In versus Monday, the prosecutor commented in his closing that it was a real honor to work for Mr. Mailing, who had recently passed away before that trial, and he was invoking the prestige of the office. Should it play into our decision at all who prosecuted this case, meaning someone in the community who I assume everyone there knows of, or knows about, who votes for, who's been around for 30 years, who's potentially vouching for the credibility of a witness? One, an opening statement saying, I think you're going to find that this child's credible, and then in closing saying that this woman committed perjury when she testified. Should it play into our decision making at all who was making those statements?
I don't think it should play into the decision. I think the evidence and the jury's decisions are what really matter here. The fact that he is the elected prosecutor, I don't think would matter. It wouldn't matter who made those statements.
I mean, there's a distinction when in Monday, if the prosecutor wouldn't have said anything and just made these terrible statements, it's one thing that he invoked the prestige of his office and then he made the statements. Here, would it be because the elected prosecutor is standing there, he's automatically invoking the prestige of his
I don't
office?
think so, no.
My question related to the comments of elected prosecutor Greg Zempel with regard to Amanda and his comment, did Amanda commit perjury when she swore to tell the truth, the whole truth, nothing but the truth, and then got up there and lied? Yeah. that's definitely something you can consider about her credibility. And to the point Judge Cooney is making, when the elected prosecutor is saying one of the witnesses lied, I mean, the word lie is not typically heard in criminal court. Is that correct?
That's correct.
Can you comment on that?
That it was improper. He should not have said that. He should not have drawn the conclusion that she perjured herself, that she lied. It would have been better had he just referred to the evidence and to specifically her testimony, but not draw that ultimate conclusion that she committed perjury. However, she was a defense witness. He was impeaching, I'm sorry, she was a state's witness. He was impeaching his own witness. And yet the impeachment evidence was not really an element or a material issue of fact in this case. It was more about her, it was her credibility, and it was improper. However, it was not, I don't think Mr. Schilling has shown that it was prejudicial, that it would influence the outcome, the verdict in this case.
Does it have any correlation or association with Judge Cooney's question about the power of the influence of an elected prosecutor making comments about opposing counsel and having that have more sway, more influence?
I don't know. This trial was over several days. The Kittitas County has approximately 44,000 residents. So it's likely that most people have heard his name, or if they voted in the last 30 years, they're aware that he's the elected prosecutor. But I don't know if anyone personally knows the prosecutor in a case. Usually they are not on the panel. So they may know that he's the elected prosecutor, but I don't think that that would have more influence than all of the evidence that was presented by the victim and by the other witnesses. Any other questions? Do I only have 33 seconds left?
Yes.
Okay, then I will ask that this court affirm the convictions of Mr. Schilling.
Thank you. Mr. Catala?
Oh, thank you, Your Honor. I'll just start right away. Should this court consider exactly who the prosecutor was in this case regarding misconduct? Absolutely, yes. And I think Your Honor's point about Monday is salient. But even without that, we know that this jury, this entire veneer, frankly, knew who this was. Multiple of them admitted it. They explicitly discussed it when they were selecting the jury. It wasn't a secret that this was the elected prosecutor in Kittitas County. Prosecutors are held to a higher standard. That's just the reality. And I think when we're talking about something like this, the identity of the specific prosecutor is relevant. The specific sway they hold over their voters, their constituents, is relevant. And when they are committing misconduct like this, I do think that's relevant in gauging the type of prejudice that flows from that type of misconduct. When the elected prosecutor comes up and says this person was lying, not only were they lying, but the lie was so significant that it rises to the level of a crime, that is very important, and it's very wrong. The ability for that to sway someone's mind is more pronounced than if it was just an average prosecutor. I want to also discuss the point that was briefly touched on regarding the impeachment. Regarding whether she spoke with Mr. Schilling in 2023, I think the state had more or less just said that that wasn't relevant, that the source of the impeachment wasn't relevant to the actual factual matter of the case. I would agree. Whether she contacted, or I should say whether Mr. Schilling contacted Ms. Cezarwinski, was not relevant to the facts of the case, the material facts of the case. While it did bear on her credibility, it does not mean extrinsic evidence is admissible to impeach her. She could only be impeached by her own statement if it's collateral. It is collateral because it's not independently relevant.
Wouldn't it go to a motive and bias, though? I mean, I'm thinking if you ask somebody, have you talked to this person recently? what you're truly asking is, are you staying connected? Do you have a bias toward this person or a bias against this person? The nature of a relationship will definitely give you a bias perspective. So when you say that it's completely collateral, because it goes to the bias.
It does. So it does go to the credibility, right? I mean, that's really what we're talking about, but that's what the collateral bar is talking about itself. We have Teal, we have Roseborough that are saying essentially that, well, if something does touch on the witness's credibility, that thing that would be used to impeach the credibility still has to be independently admissible. That's why it's a risk for a prosecutor to make the venture essentially when they're cross-examining or examining a witness where they're asking something that could potentially impeach. They're stuck with the answer. That is very clear. I mean, that's why this collateral bar exists. We don't want things to get confused and sidetracked in trial.
Trials.
Exactly. Regarding the denigration of counsel, so what was said in voir dire, there was a bit of informality between both counsels. There's no question about that. I don't think in any way, shape, or form does that detract from what happened days later during the rebuttal, when the entire theme of the rebuttal was that this person is essentially a spinster, they're lying to you, disregard everything they said entirely. We can't ignore the explicit language that the jury heard. It's also important that the jury heard that right before deliberation. The defense counsel had no way to rebut that. And that was the last thing that was stuck in the jury's mind before they were going in the deliberation room, was that this person just sat up there, lied. They're a Hollywood screenwriter. It's this latest rendition of whatever Hollywood story they're writing. It's the last thing that the jury heard before the deliberation room. I think that's incredibly important.
If he had gotten up and said, there's no evidence to support what defense counsel, the version that defense counsel just told you, would that be wrong?
That's fine. That's fine.
So where does it cross the line?
It's this. Can I respond, Your Honor?
Yeah.
It's the specific language that's being used. Thorgerson and Lindsay are instructive. When you're saying something isn't true, that's fine. But when you call it a crock, that's passing the threshold. Right. Same thing here. When you're calling
it a sleight of hand.
Sleight of hand, exactly, Your Honor. Utter fiction, something that you should disregard entirely. This Hollywood rendition is the specific inflammatory language that's relevant here. It's not just saying it's wrong, it's saying, you're really embellishing and inflammatorily embellishing how wrong it is. We are asking for the court to reverse the 3 convictions. Thank you, Your Honors.
Following these arguments, the court disagreed that Mr. Schilling received ineffective assistance from his trial counsel. They agreed the court erred in allowing inadmissible hearsay, the prosecutor committed prejudicial misconduct, cumulative error deprived him of a fair trial, and the evidence was insufficient to support a conviction for indecent exposure. The court reversed the child molestation in the first-degree convictions without prejudice and remanded for a new trial. They also reversed the indecent exposure conviction and dismissed with prejudice and declined to address the challenged conditions of community custody. Please let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for new arguments every week.